The background was the following. Max Schrems, a law student from Vienna, had, for various reasons, felt that the protection of his data was not guaranteed in the United States, and had brought two complaints. One before the Luxembourgish Data Protection Authority against the company Skype, which is located in Luxembourg, and which had been bought by Microsoft in the United States. And ever since Microsoft had bought Skype, the processing of the data, which was running via the Skype system, was undertaken in the United States. And the other complaint was before the Irish Data Protection Commissioner in Dublin against Facebook Ireland, Facebook Ireland being the subsidiary of Facebook, which handles all contracts of all users of Facebook outside of the USA and Canada, so roughly 1.5 billion users worldwide, which all have a contract with Facebook and therefore are within the, just for that reason already, are within consumer protection and data protection rules under the European legal order. Now, the complaint against Skype's handling of the data, especially Skype's privileged partnership through its owner Microsoft with the NSA, following the Snowden revelations about mistreatment of data and lack of protection of privacy and data protection standards by the NSA, was treated by the Luxembourgish Data Protection Authorities. A decision was made. At the same time, the decision of the Irish Data Protection Commissioner, who had received the same set of complaints against Facebook, was rather shorter. It simply, to put it in general terms, stated that the complaint of Max Schrems was inadmissible because the Irish Data Protection Commissioner had no possibility to investigate how the United States and how authorities of the United States were handling European data after transfer to the United States, because of the existence of the so-called Safe Harbor decision, which was a decision under the Data Protection Directive, which allowed the Commission to establish that a third country, in that case the United States, had a level of protection which was adequate under European data protection standards, and that therefore there was no limitation of transfer of data from Europe to the United States. Now, this decision by the Data Protection Commissioner was subject to judicial review in the High Court of Ireland, and Justice Jared Hogan took a decision to request a preliminary reference from the Court of Justice under Article 267 of the TFEU to review the legality of this Safe Harbor decision. Also, the decision of Justice Hogan was rather complex, but at the end of the day, that was the question. The question was, does this comply with the standard of protection we have under European law? And he added that if the Irish constitutional law were applicable, surely the standards would not be sufficient. Therefore, the question had arrived before the Court of Justice, and I had the pleasure to have been working with Max Schrems for a couple of years beforehand, discussing these matters. And so, given my Irish and Luxembourgish background from my career, which you had heard earlier, I put together a team from Irish lawyers and myself, by which we were together representing Max Schrems in the Court of Justice in this preliminary reference procedure. Now, the answer of the Court of Justice was quite impressive, at least by the nature of how case law runs. It was a bombshell for many aspects. For the first time in Schrems against DPC, the essence not only of substantive fundamental rights was found to be attacked. In that case, it was a question of privacy and data protection. But also the Court of Justice found that the essence of the right to an effective judicial remedy under Article 47 had been violated by an act of the European Commission. And this double violation of the very essence of the right, which is a first in the case law of the Court of Justice, helped to understand what does it mean to have the essence of the right, and on the other hand, clearly drew lines as to how far can a union institution go in the area of limitation of fundamental rights. The other important aspect, obviously, was to establish how European fundamental rights are to be exercised in the digital age, where the classic notions of territoriality and territorial reach of law aren't as clearly delimited as they used to be in an analogous age of classic trade between borders. In the digital age, obviously transfer of data takes place rather fluidly on a daily basis around the world. Just think of what happens when you send an email. Little parcels of data are sent around the world, and you don't even know which data centers they cross. Even if you just Skype between one room and another room in the same house, the data packages can be traveling the entire world. Now, that being so, the question is, what is the territorial reach of a right such as the right to privacy and data protection? And the Court of Justice, by taking privacy and data protection in the digital age seriously, in the sense of saying this is a right which has to be protected for a user within Europe, has applied what in competition law was used to be known as the effects doctrine. If the effect of a violation is in Europe, European law is applicable. Now that in itself, of course, is, as it's known from competition law, has been applied to the internet age, but the clarity by which this is then pronounced and the effects, for example, towards transfer of data across the Atlantic, which is one of the backbones of the internet, has huge implications. Now, the third element of this case, which is sometimes a little underreported, is the importance of the duty of care, the importance to take into account all relevant elements of a case, and where a decision, like a decision of the Commission, which was in the case taken in the year 2000, as to the compliance of the United States with standards of data protection under European law, the Commission has not only the obligation to take into account all relevant facts when it takes a decision with effect to the future, but there are certain types of decisions which have to be reviewed on a more or less periodic basis. And the fourth element is, of course, the obligation of cooperation between member states, authorities, and the European Commission in ensuring that where there are doubts, that these doubts are not only identified and communicated, but also acted upon.